Welcome to Engaging Experts, the podcast that goes behind the scenes with influential attorneys. Our guests will describe their practice and expertise. Then we will go deep on various topics related to effectively using expert witnesses.
Hi, this is Russ Rosenzweig. I am the CEO and co-founder of Roundtable Group, and also the host of this podcast series called Engaging Experts. We have a great guest for you today, Chris Mammen, an intellectual property litigator at Womble Bond Dickinson in Silicon Valley, and a thought leader on artificial intelligence. So we're in the expert witness business here, and it's always great when we have a guest who's both an attorney and an expert. And before we get started, here is our sponsorship message.
This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Welcome, Chris. Happy New Year.
Happy New Year to you. Thanks for having me in today.
So excited to have you here. Today we'll be meeting with Chris Mammen, an IP litigator at Womble Bond Dickinson. And in this podcast, we'll be discussing Chris's background and his practice. We'll chat about how Chris uses expert witnesses in the course of his practice. And then we'll dive into a very cool and interesting topic related to AI, artificial intelligence, and the copyrightability of things that are created by AI.
And patentability.
And patentability, right. And maybe we can get you to talk about the differences between the two to some of our lay audience members. But let's maybe start with where it all began, Chris. After you graduated from Cornell Law School, you went on to Oxford to earn an advanced degree in legal philosophy. And I'd love to hear more about that decision to delay the practice of law to study at Oxford instead. What was that like, and how has it influenced your legal career?
Well, sure. To some extent, it was a really easy choice. As I was getting ready to graduate from law school, and I was faced with the choice of being a first-year associate in a large law firm, or going off and living a Brideshead Revisited fantasy life at Oxford. So in that sense, it was really an easy choice. But in another sense, I had spent much of my undergraduate career and to a certain extent at law school studying legal theory and legal philosophy. And so to have a chance to go spend some time at Oxford, where H.L.A. Hart and Ronald Dworkin and John Finnis and other luminaries in the field had lived and taught, was just a fantastic opportunity. And so I spent 3 years there working on a PhD in legal theory.
Tell us just a little bit more about it. I understand your dissertation was 400 pages. What was it about, and what were some of the things specifically that you studied there? I think a lot of your peer lawyers would be intrigued to know.
Yeah, so going to Oxford as a doctoral student basically meant that I was welcomed. I was given a seat in the library and invited to check back in when I had finished my 100,000-word dissertation. I wrote my dissertation on using legislative history in statutory interpretation. So it was, very much focused on, digging into some of the legal philosophers and Supreme Court case law and some comparative British case law on how legislative intent, or the documents that are commonly associated with legislative intent, are to be used in interpreting statutes. And so it was a really fun and interesting topic. Got a chance to bounce those ideas off of some of the great professors there, and some of my fellow students who've gone on to themselves to do great things. And so, the life of a graduate student there was many hours in the library, but then punting and dining in 18th century dining halls and all of those kinds of things as well.
Well, interpreting legislators and their legislation is kind of a hot topic today and is constantly on the news. And, how did you go from that to decide to become an IP lawyer?
To a very great extent, patent litigation is about interpreting language, interpreting legal texts. Instead of statutes, though, it's interpreting patent claims and figuring out what the words of patent claims mean. And so I think to a great extent the work I did and the methodologies that I studied and learned about as a graduate student helped in being a patent litigator and working on these questions of interpretation. So when I finished as a graduate student, I moved to San Francisco and joined a law firm just as a general litigator. This was in the late 90s, so sort of on the eve of the first dot-com boom, and had an opportunity while there to start working on some patent cases. And it was a great time to get into patent law and IP litigation and learn from some of the best Silicon Valley IP litigators working at that time. And that sort of made the switch for me into IP litigation.
I too well remember the dot-com era. Roundtable Group was just launching at that time, and an incredibly exciting time. And we also spent a great deal of time in San Francisco and in Silicon Valley during that era. And maybe you can tell us a little bit about how your IP practice has evolved from then to the present. And, a lot of our listeners are fellow peer business owners like me who run 10 to $100 million companies and are members of the YPO and various other organizations of business owners. And I think they'd be quite interested to hear about the specifics of your current practice and how you might be helpful to executives and business owners who are facing IP issues.
Sure. So, a lot of what has evolved in my practice over the years is a progression from working on just one case at a time or sort of the massive cases and focusing on the particular legal issues that I was assigned to work on as a junior lawyer, to really being attuned to my clients' business interests and how IP helps serve overall their business interests. I have spent a good amount of time advising IP strategy as well, or choosing whether a particular dispute is better served talking about patents or copyrights or trade secrets, and how those further the overall business objectives. And the same is, when litigation happens or is inevitable, figuring out the best way to move through that litigation in furtherance of the business interests. I work in a wide range of fields. As a philosopher by training, I can't claim specialization in any particular scientific field, but I think that has helped, because particularly in litigation, so much is about telling the story of the dispute and reducing the complex technology to something that is understandable by the judge and by a lay jury. And so being able to stand in the middle of that role as a philosopher storyteller, mastering the technology has worked out pretty well.
Now, Chris, we've had the pleasure to walk alongside you and many of your colleagues at Womble Bond Dickinson and even its predecessor firms, going back 25 years, on the expert witness side of those IP matters. And the title of our podcast is Engaging Experts, and part of our goal here is to educate fellow litigators on tools and techniques in the expert witness context. So I'd love to hear a story or two about how you use expert witnesses in your IP practice, and some tools and techniques that you might share with your peers.
So, I would say that particularly in patent litigation, but in IP litigation generally, experts are critically important. They're important to help us lay lawyers or non-scientific lawyers understand the technology and to develop theories of the case. And so it's really important early on to get those experts involved and to begin working with them right away. A typical patent case will involve both a technical expert as well as a damages expert. And it's in finding the right expert to help in a particular case. It's like trying to boil the ocean. If we were to go out into the universities or wherever else people have sort of self-identified as experts and try and find the one that has just the right technical expertise and has the right disposition to be a good witness. And so it's really critically important to us to work with organizations like Roundtable Group to help us locate and vet those experts. And I'll share with you just one story. This was from the very first patent trial I was involved with. We had an expert, and the other side had a technical expert, and they both got up on the stand and told their stories about why they were qualified. And the expert on the other side was a very distinguished professor, and he got on the stand and talked about all the many dozens of technical articles that he had written and published, and how many classes he had taught and so forth. And our expert got up on the stand, also very distinguished, maybe not quite as many articles that he had published, but then he said, "I helped design the communication system for the space shuttle."
Wow.
And just that little bit made him really relatable, made the jury perk up, and he had the jury's attention and the greater credibility from then on out for the rest of the trial. So, helping to find and vet experts who not only know their stuff, but have that kind of a little perk that can help drive home the credibility with the jury is really key.
Well, I love expert stories like that, success stories, and thanks for the nice plug. And it really means double coming from you, being an expert, an Oxford-trained philosopher, as well as a litigator. So thanks for that. And, Chris, I want to kind of dive into your current area of expertise and thought leadership, which is AI, artificial intelligence, which is kind of the hot topic du jour. And, we're constantly talking about it, not only in the legal context, but my fellow entrepreneurs and executives. I mean, this is all we talk about these days, how to more effectively and efficiently integrate AI into our various businesses across the board. And, even here at Roundtable Group, we're utilizing AI techniques to assist us with that very process you were describing of helping IP lawyers to more efficiently locate and engage experts. And even some of the household names in our world, some of the tools that we use to find experts like Google Scholar, Microsoft Academic, A Minor, are actually chock full of cutting edge AI algorithms. And unlike when we got started 25 years ago, we have access to like every article that's ever been written on any topic. And, in 5 minutes, with the help of some AI, can track down the authors who, have written articles on it and get them on the phone. So it's really transformed our world here. And, recently I watched a robot create a magnificent work of art. And I feel like we're starting to live in the world that Isaac Asimov, one of my author heroes, wrote about decades ago. So maybe you can tell us a bit about copyrightability and patentability in the AI context. And, I'm also just really curious if that robot's piece of art is like copyrightable.
Yes. No, that's a fantastic question. It's a really good place to start. There is so much that's being done with AI, both in sort of what I'll call the creative arts, though I think that calling them that sort of presupposes an answer to the question, just as referring to inventions by AI also presupposes an answer to a question. But this question of, is the robot that has created a visual image, is it art and is it copyrightable? And to some extent, under current doctrine, the answer to the copyrightability is probably no, because at least in U.S. law, the requirement is that there be sufficient human involvement in order for something to be copyrightable. And so, if something is purely generated by the robot, then it's probably not. Now, if the robot has been programmed in a certain way by someone who's exercised the creativity, then it's entirely possible that person may provide sufficient human involvement for it to be copyrightable in the name of the programmer as artist. But in the sense that the robot as artist, it's not going to be something that can be copyrightable. And one of my favorite illustrations about this point is a couple of years ago, there was a case that got a whole lot of press. It's referred to as the monkey selfie case. There was a nature photographer that set up his camera in the jungles of Indonesia and left it just to sort of see what might happen. And some very photogenic monkeys came up and were playing with the camera. And so there were a number of photos that were recorded that looked like the monkey was taking a selfie, smiling and taking a selfie. And it led to a series of litigation about whether the nature photographer could own the copyrights in those images. And indeed, animal rights groups got involved and were arguing that the monkey should have the copyrights in those works. And those cases led to some of the doctrinal rulings about needing to have a human artist. And so there's an extrapolation from that to the AI sphere. But there are some other interesting questions about copyright law that I'll touch on, and then we can talk a little bit about patent law. Questions, there's a project going on right now called Next Rembrandt, and it's an organization that has used AI to train their models using Rembrandt's corpus of work to create another image that looks very much like the style of a Rembrandt painting, but is very different. And so it also provides a number of interesting questions, which, if we were to say, okay, it is copyrightable, who is the creative force behind that? Is it the AI or is it Rembrandt himself? Because all of the creative inputs that it's been trained on were all Rembrandt's works. And if it's Rembrandt, and under our current copyright law, a copyright's valid for the life of the author plus 70 years, then wouldn't that copyright have expired hundreds of years ago before the work ever came into existence? So we get sort of tied up in these pretzels that the philosopher me really loves to entertain.
There's a lot of art lovers, myself included, like back when the world was open And I was regularly traveling the country to meet with our beloved clients and expert witnesses in all our great cities. I would always make it a point to visit the local museum, and had this technique where I would, when permissible, take a picture of my favorite artworks, and this included all the Rembrandts if there were any. So I have this collection of just self-taken photos of Rembrandts, among other artists, from museums around the world. And I set up just this private little system where they show up randomly on my screen, so I can take a break and enjoy a piece of art periodically throughout my day. And I've actually, as a layperson, become pretty good at, you show me a piece of art, I'm getting pretty good at guessing who the artist is. If you showed me something from next Rembrandt that was done by the algorithm, and, having been enjoying pictures of 100 Rembrandts over the past couple of years, I would just look at it and say Rembrandt. So I'm curious about, just tell us more about some of the nuances regarding, copyrightability along these lines as AI just becomes more and more commonplace and talented.
Yeah, so that it raises an important question, and that is, if we assume that something similar is being done for a living artist, whether it's a visual artist or a musician, and we train an AI on their corpus of work, and then can create at the speed and volume that a computer network can create, we can create a whole bunch more works in the same style. What does that imply? What flows from that? Well, one inference is that could jeopardize the livelihood of the artist, the human artist, by diluting the marketplace. Something else is whether the use of that corpus of work, the collection of Rembrandts or all of Britney Spears recordings or whatever, as training data, whether that is fair use to use that as training data for the creation of additional AI created works. And so there's a bunch of sort of follow-on questions that arise out of that. Another thing I wanted to comment on is there's a way in which the AIs, because the algorithms can sort of detect what makes something characteristically a Rembrandt or characteristically Bach or Mozart music. I've heard some examples of an AI-generated Bach work and compared with an actual Bach work, and most people will pick the AI-generated one because it's got all of the check marks sort of elevated to a caricatured level of what you look for. If you've taken, like I have one music appreciation class to spot the work, and so that's something else to sort of be interested in as this continues to develop.
For those of our listeners, Chris, who really want to go deeper on this topic and legal aspects, can they reach out to you? Maybe you have suggested readings, etc.
Absolutely, yeah. I've happy to have folks reach out to me either on LinkedIn or at my email address, chris.mammen@wbd-us.com.
And before we go, I want to talk about patent law too in the context of AI. Do you want to share some kind of cutting edge things going on in that realm?
Yeah. So when we talk about AI in the patenting realm, there's really sort of three buckets that we can divide things into. One is using AI as a tool, as a research tool. It can help the chemist researcher more quickly identify promising drug compounds, for example. So it's a research tool. There's another bucket where the AI is the invention. Think about all the technology that goes into self-driving cars or all our speech recognition tools or things like that. And the third area that I've been spending a lot of time in is the question of whether an AI can be an inventor. We've spent a lot of time talking about AI and copyrights. There's a similar discussion going on about AI and inventorship. A couple of years ago, a professor named Professor Thaler and a law professor from the UK named Ryan Abbott filed some patent applications in the name of an AI called Dabus. And these inventions and these applications drew a lot of headlines about a year and a half ago. And the patent offices in the UK and the European Union and the United States all eventually rejected the patent applications for two reasons. One was that in every one of those jurisdictions, an inventor has to be a human. And the second reason is sort of the gets at the practical questions. Basically, Dr. Thaler, you're filing this application on behalf of Dabus. How do you know that Dabus wanted you to file this patent application? How did Dabus tell you? And the answer to that is clearly no, because we don't have general purpose AIs that are sentient beings that can express themselves in that way and sign contracts and have legal agency.
Not yet, anyway.
Not yet. That's right. Someday we may well. But for right now, the doctrine does not support AI as inventor. It has led to a debate about whether or not this is how it should be. And on the one side are what I call sort of the humanist approaches, where the purpose of patent law, the purpose of IP law, in copyrights and patents in particular, is to encourage creativity and inventiveness as human activities. The other side is more of a question of industrial policy, that regardless of how we got there, if we have something that's new and useful and valuable, then it should be protectable and protected against knockoff copying. And so I think we'll expect to see over the next several years, as AI continues to improve, maybe to the point of having legal agency, maybe not, we will continue to have a debate between those who advocate the humanist creativity, inventiveness approach, and those who advocate the industrial policy approach.
And which side would you say you're on?
As a philosopher, I tend to come down on the side of the humanists.
I think I agree. And any other just kind of last thoughts? Anything you're seeing kind of cutting edge, new developments at the intersection of AI and the law and philosophy that you'd like to share with our listeners?
Well, shifting topics just slightly and talking to those of the listeners who are practicing lawyers or working with practicing lawyers, there's also a tremendously interesting arena where we use AI tools in our practice, and questions of legal ethics and related issues that arise out of that intersection of using those tools in practice. And subject for a whole additional podcast episode, but it's also very interesting.
Well, that's really new, exciting news for me, because the industry of the law is, how do we say, not always the first mover in terms of adopting new innovations. So I wasn't aware that AI is now front and center, even within the very process and practice of the law.
Yeah, it's been there for a long time in some areas, like our legal research tools have been moving ever closer to, or ever deeper in AI type tools. Electronic discovery has made extensive use of AI, but it's getting farther and farther into various aspects of our practice. I saw something not long ago that purported to be something that could write briefs for you, or at least generate a rough outline of a brief based on AI tools. I don't think we're yet at the point where associates are going to find competition from AI lawyers, but there are a lot of things that we can harness in our practice.
Yeah, Chris, we were recently approached by a startup that is building an AI that claims to, you plug in the complaint and out will come the perfect experts to be engaged. And I just wasn't sure if I should feel fear or feel like I should buy them right away or laugh about it. So it's really interesting how quickly it's developing in so many fields.
Yeah, absolutely. And you should probably feel all three of those.
What a rich discussion, Chris. I just really enjoyed the breadth and depth of our topics. And thank you so much for participating.
Well, thank you for setting this up. I enjoyed having the opportunity to talk with you and your listeners.
Chris Mammen, ladies and gentlemen, from Womble Bond Dickinson in Silicon Valley. Thanks for listening to the Engaging Experts podcast. See you next time.
Thanks for listening to Engaging Experts. Be sure to click subscribe so you don't miss our future episodes.